We are committed to ensuring the safety of our community. Our law enforcement partners are working diligently. We need your support.
In 2019, prosecutors in Pennsylvania launched a grand jury investigation into the organization known as Jehovah's Witnesses. The probe focuses on allegations of child abuse cover-ups and internal policies that may have protected offenders. What you are about to hear is not a story that began with a single complaint or a single victim. It is a story that began with a system. A system carefully constructed over decades, designed to keep secrets inside, to move problems quietly, and to protect an institution at the expense of the most vulnerable people inside it. And in Pennsylvania, for the first time on American soil at this scale, that system cracked open under the weight of government power. By 2026, what started as a state investigation has become the largest criminal probe in the history of Jehovah's Witnesses in the United States. Police raids, grand jury subpoenas, dozens of convictions, sentences stretching to 30 years behind bars. And at the center of it all, a secret database hidden for decades inside the walls of Watchtower's world headquarters in New York. A database that prosecutors believe holds the names of thousands of accused abusers that the organization never reported to law enforcement. Today, we are going to walk through the exact timeline of how this investigation unfolded, what has been uncovered, what is still being pursued, and why the men who lead this organization from their compound in Warwick, New York, are facing the most serious institutional threat in the religion's entire history. This is not about theology. This is about criminal accountability, the culture of silence. For decades, the Jehovah's Witnesses organization operated on a foundational principle when it came to internal wrongdoing: handle it inside. If a member committed what the elders classified as a serious sin, including sexual abuse, the response was dictated not by law enforcement protocols, but by a set of internal policies flowing directly from the headquarters known as Bethel. Elders were trained to convene a judicial committee, 3 men from the congregation, to hear the matter privately. Victims and their families were often counseled against going to the police. In many cases, they were explicitly told that reporting abuse publicly would bring reproach upon Jehovah's name. This framework has a name inside the organization. It is called theocratic order, and for generations, it worked as a near-perfect shield. Members who had been baptized since childhood trusted their elders completely. They had been taught from the time they could read that the organization was the sole channel of communication between God and humanity. To question an elder's instruction was to question God himself. In that environment, a young victim who dared to report abuse to the police risked being seen as a spiritual problem rather than as someone who had been harmed. But outside those kingdom halls, the world was changing. Beginning in the early 2000s, investigators in Australia, the United Kingdom, and the Netherlands began documenting what appeared to be a global pattern. Internal Jehovah's Witnesses documents surfaced in civil litigation, showing that headquarters had known about accused abusers in their congregations for years, sometimes decades, without ever alerting authorities. In Australia, a royal commission found that the organization had records of over 1,000 alleged perpetrators going back to 1950, none of whom had been reported to police through the organization's own initiative. Pennsylvania prosecutors were watching all of this. And in 2019, they acted. The grand jury and the 2-witness rule. The grand jury is one of the most powerful investigative tools available to American prosecutors. Unlike a trial jury, which decides guilt or innocence, an investigating grand jury exists solely to gather evidence, issue subpoenas, compel testimony, and determine whether criminal charges are warranted. When a grand jury issues a subpoena, compliance is not optional. You do not consult with your congregation elders about whether to appear. You do not call Bethel for guidance. You sit down in front of prosecutors and you answer questions under oath, or you face criminal contempt charges. This is precisely what made the Pennsylvania grand jury so significant. For the first time in the United States at this scale, the internal chain of command within Jehovah's Witnesses was being forced into the open by law. Elders who had spent years believing that their congregational authority insulated them from secular scrutiny were now sitting in government offices, explaining under oath exactly how abuse reports were handled, who gave the instructions, and where the paperwork went afterward. What the grand jury built, over months and then years of testimony, was not just a collection of individual cases. It was a map. A structural map of how information about abuse traveled through the organization, from the congregation level up through circuit overseers, and ultimately to legal departments in New York that coordinated responses and documented accusations in files that were never shared with law enforcement. Prosecutors were particularly focused on a policy that has drawn international attention and condemnation, the two-witness rule. This rule is derived from a biblical passage in Deuteronomy and has been applied by the organization's leadership to mean that an accusation of abuse cannot be formally acted upon unless there is a second witness to the act itself. In practice, this means that a child who comes forward and says they were abused by an adult in the congregation will frequently see no congregational action taken, because abuse almost never happens in front of witnesses. The accused is allowed to remain in full standing, to continue attending meetings, to continue working with children in service, while the victim lives in the same spiritual community, told to wait on Jehovah to bring justice. Pennsylvania prosecutors did not find this policy to be a sincere religious practice deserving institutional deference. They found it to be a mechanism that predictably and repeatedly protected offenders from accountability. The arrests and convictions. Between late 2022 and throughout 2023, the results of the grand jury's work began to materialize in public criminal charges, and the scale of what was announced shocked observers even outside the religious freedom debate. Take the case of Norman Avils Garriga, a congregation elder in Lancaster County. For years, he was exactly the kind of man the organization holds up as a spiritual model. Trusted by families, present at meetings, active in the ministry. Over the course of several years in the early 2000s, he abused multiple children in his congregation. When two of those victims eventually found the courage to tell congregation leaders what had happened, those leaders did what Watchtower policy instructs. They handled it internally. They did not call the police. They did not file a report. The abuse was never disclosed to secular authorities until years later, when one of the victims told an outside counselor, and the information finally reached the office of the Attorney General. By then, the children had been carrying what happened to them for over a decade without justice. A jury convicted Aviles Garriga on all 12 counts after a 3-day trial. When the judge sentenced him, he told the defendant that if he found the sentence harsh, he should consider that the number of years he would spend in prison matched almost exactly the number of years his victims had spent waiting for someone to believe them. He received 11.5 to 23 years in state prison. But Aviles Garriga was not an isolated case, and that is precisely the point the grand jury was building toward. Luis Manuel Ayala Velázquez, from Reading, was sentenced to up to 46 years. Mark Brown, from Pittsburgh, pleaded guilty to felony charges involving 2 children and received up to 30 years. In case after case, investigators found the same architecture underneath the individual crimes. A victim who had told someone in the congregation, elders who had been informed, a phone call to Bethel's legal department in New York, and then silence. No police report. No referral to Child Protective Services, a judicial committee, a private deliberation, and a decision that the matter would remain inside the organization. One case that prosecutors described in particular detail involved a young girl who had been abused beginning at the age of 7. The abuse continued, by her own account, somewhere between 50 and 75 times before she finally told someone she trusted in the congregation. That person went to the elders. The elders followed their protocol, and the perpetrator continued living in the community while the girl continued attending the same meetings, sitting in the same kingdom hall, in the same rows, under the same roof. The men who were convicted were not figures operating on the margins of the organization. They were elders, ministerial servants, men who gave public talks and led Bible studies, and were introduced from the platform as examples of faithful service. And in every case the grand jury examined, the institution's response followed the same path. Not toward the child, but toward organizational self-protection. Pennsylvania law is explicit on this point. Clergy in the state are mandated reporters, which means that if a religious leader has reasonable cause to suspect that a child is being abused, reporting that suspicion to civil authorities is not optional. It is a legal obligation. The organization was aware of this requirement. They had been told. And the evidence assembled over years of grand jury testimony suggests that they made a calculated choice, across multiple congregations, across multiple decades, to treat that legal obligation as secondary to the internal chain of command that runs from the Kingdom Hall floor directly to the legal department in Warwick, New York. By the middle of 2025, the investigation had produced at least 16 arrests and 11 convictions across the state of Pennsylvania. The sentences were severe. The message from the justice system was unambiguous. Watchtower's internal policies would no longer function as a substitute for criminal accountability. The secret database. But the individual convictions, as significant as they are not what is keeping the governing body of Jehovah's Witnesses awake at night in 2026. What is keeping them awake is the database. For years, researchers, journalists, and attorneys in civil abuse cases have referenced what insiders describe as a confidential archive maintained by Watchtower's Service Department and Legal Department at Bethel headquarters. This is not a digital rumor or a conspiracy theory. It has been referenced in depositions, discussed in court proceedings, and partially described by former Bethel employees who worked in departments adjacent to where such records were kept. The archive contains, by various estimates, the names of tens of thousands of individuals accused of abuse within congregations globally. In the United States alone, the numbers that have surfaced in civil litigation suggest the database could contain files on more than 20,000 individuals. For decades, this archive existed in a legal gray zone. Civil attorneys in abuse cases tried to subpoena it and frequently ran into walls of attorney-client privilege claims and jurisdictional arguments. Watchtower's legal team is sophisticated, well-funded, and experienced in exactly this kind of litigation defense. They have fought disclosure of these records in courts across the country and around the world. The Pennsylvania grand jury changes the equation in a way that civil litigation cannot. A grand jury investigating a criminal conspiracy to obstruct justice and cover up child abuse is not limited by the procedural constraints that slow down civil plaintiffs. If Pennsylvania prosecutors succeed in compelling the production of those files in the context of a criminal investigation, the contents would not simply belong to a civil case that might settle quietly out of court. They would become part of a criminal record, potentially subject to public disclosure, potentially available to prosecutors in every other state who have been building their own cases. That is the doomsday scenario for the organization. Not losing a civil lawsuit, not paying another settlement, but having the full contents of that archive exposed in open criminal proceedings, proving conclusively, with the organization's own documentation, that the institution knew the scale of the problem for decades and chose organizational protection over the safety of children. In 2025, Watchtower's legal expenditures related to abuse litigation and investigation defense reached figures that observers who have tracked the organization's finances for years cannot easily dismiss. The organization has spent millions fighting subpoenas, millions in settlements that almost always include confidentiality clauses, and millions more in lobbying efforts in various states to prevent the elimination of statutes of limitations for child abuse claims, legislation that would open the door to thousands of additional lawsuits. In Norway, the organization has already been stripped of government subsidies due to findings about their shunning practices and internal judicial policies. In Spain, investigators have been building their own parallel case, but none of those international pressures carry the specific weight of a criminal grand jury in the United States, where Watchtower is incorporated, where its financial assets are held, and where its governing leadership physically resides. What Pennsylvania has built between 2019 and 2026 is a legal foundation that other states are now studying closely. The prosecutors who led this investigation have documented their methods for penetrating the internal chain of command of a high-control religious organization, and those methods are available to district attorneys in every other jurisdiction where these cases have been building quietly for years. The governing body has told its members for generations that the organization is impossible to bring down by human forces. They have pointed to previous controversies, previous lawsuits, previous exposés, and said, "We survived all of that. We will survive this too." But 2026 is different, because for the first time, it is not critics or journalists or civil plaintiffs driving the pressure. It is the criminal justice system of the United States, focused not just on individual perpetrators, but on the institution itself. The blue envelopes exist. The prosecutors know they exist. And the battle over whether their contents will ever be fully exposed in an American courtroom may determine the future of this organization more than any doctrinal shift or membership decline ever could. If you were ever inside this organization, you already know how carefully information was controlled. Leave your experience in the comments, because those stories matter, and because the more people who understand how this system actually functions, the harder it becomes to hide behind claims of religious liberty. Share this video. Subscribe if you haven't already. The investigation is ongoing. The story is not finished. We will keep following it. See you in the next one.